I'm James Vickman. I'm a practicing attorney in Beverly Hills, California. I have a general practice emphasizing litigation. This series is entitled Breach of Contract, and this is part one of that series, and part one is called Meeting of the Minds. And so in a contract, there has to be a meeting of the minds in order for the contract to be enforceable. That means in order for you to be able to sue on the contract, both sides of the transaction, you and the other party, have to have had a meeting of the minds on all the main terms. If there was no meeting of the minds, in other words, if one person thought that one of the terms was X and the other person thought that that same term was Y, a very different product or service, then there was no meeting of the minds. Also, for example, let's say it was a services contract, that one of the people, let's say the person that you were contracting with was to provide a service to you. Let's say to a consulting services for your company to help your company improve its profits, have less expenses, be able to track its employees better in terms of what projects they were working on, project management, consulting services. And let's say that you thought that services A, B, and C were going to be provided by the other person to the contract, and the other person thought that he or she was going to be providing services B, C, and D to you. And so there was no meeting of the minds on this service A. And let's say that service A was a very important service that you wanted, and without service A, then service B and C really didn't mean very much to you. You felt you had to have service A, but the other person to what you all thought was a contract didn't even agree to provide service A. So there was no meeting of the minds there on the service. Let's talk about another area of meeting of the minds that is very important in contracts, and that's the timeline for the providing of the goods or the services. Let's say that you were ordering 100 shirts for your store, and you wanted those shirts in 3 weeks, and let's say you needed them delivered by December 5th because it was just before all the holiday sales to your retail location and all the people would be coming in and buying shirts. And so let's say again, you thought that December 10th was the date of December 5th, December 10th was the last date of the delivery of the shirts. And let's say that the other person thought that the shirts could be delivered on December 20th. However, you knew that your main sales were between December 10th and December 20th, and you didn't get the shirts till December 20th, and then 80% of your customers had already done their holiday shopping, but the person delivering you the shirts, he thought December 20th, and so anyway, when the shirts come on December 20th and he demands payment for the shirts, and you say, no, I told you I want the shirts on December 10th. And he said, well, no, you told me December 20th. And if you can show that there was no meeting of the minds as to the date, then the person selling you the shirts cannot what's called enforce his or her contract. Let's talk about another area where there needs to be meeting of the minds, and that's the cost of the contract. That's in that same example. Let's talk about the shirts. Let's say that you thought that the shirts that you were purchasing were going to cost you $200, and the person on the other side who was selling you the shirts, he thought that the contract price would be $250. And then the shirts are delivered, and there's an invoice in there for $250, and you look at it and you say, what? Like, I agreed to $200 to buy these shirts from you. And he said, well, no, it was $250. And if you can prove that there was no meeting of the minds, that you said you thought $200 and he thought $250, then there's no contract, and you probably can get out of the contract. So those are some of the examples where there's no meeting of the minds. Now let me give you another example of where there would be no meeting of the minds, and that's where there's a mistake. And some of what I just mentioned could be mistake, but this is a story that a friend of mine just told me probably 2 weeks ago, where there was an extensive negotiation. In that case, it was a written contract between a major corporation and a company that this major corporation sold products to. And there were back and forth, probably 10 different transmissions by email of the contract that was going to be between this major corporation and this customer of this major corporation. And the revisions of the contract, like I said, there were a whole bunch of different revisions sent by the in-house counsel of the major corporation to the chief financial officer of the customer of the major corporation. And finally, everyone thought there was an agreement and meeting of the minds. And so the general counsel of this major corporation sent over the last revision, and there was a cover letter to that last revision, and it said, okay, so here is the final revisions. I haven't made any changes as compared to the last revisions, and please sign. And so the customer of this major corporation, he looked at the cover letter. He didn't want to bother to read over the contract again. He relied on what was in the cover letter from the general counsel of this major corporation, and he signed the final revision and sent it in. And then a year and a half later, when there was a disagreement on one of the major terms, and the corporation said, no, like, we told you that there was a final revision and that the term was such and such, and you even signed it. And the general counsel for the corporation presented the final contract with the actual signature of the company chief financial officer, and the chief financial officer said, I signed that. And the general counsel of the major corporation said, you sure did, and here it is, and here's the provision in there that you agreed to, and we're enforcing that, and you have to remain our customer for the next 2 years. And the customer, through the chief financial officer, said, I only agreed to a 1.5 year contract, and you're saying it's a 3.5 year contract. I never agreed to that. And then again, the general counsel of the major corporation said, well, it's your signature. And so anyway, litigation started, and the counsel for the attorney, that is, of the customer, whose chief financial officer was doing the negotiations at the time, the attorney did what's called discovery and asking for all written documents relating to the contracts and the different versions. And the major corporation then presented this cover letter from the general counsel of the major corporation saying, this is everything, it's the same, no changes from the last revision. Well, the attorney for the customer went back and found the 9th revision, and that provision in there is saying that the contract was a 3.5 year contract. It wasn't in that 9th revision. It was in the 10th revision, but the 10th revision was accompanied by that letter from the general counsel of the major corporation saying, this revision is the final revision, it's the same revision as whatever the date was that was the 9th revision. And the attorney for the customer showed the general counsel, when there was a mediation, showed the general counsel the cover letter to the final revision saying there's no changes in it. And the general counsel turned white and said, wow, I sent that with the final revision. And the lawyer for the customer said, you sure did. and so this major corporation just walked away from the deal, could not enforce the 10th revision. That's called no meeting of the minds, and that probably would potentially could have been a fraud claim too. So that's another example where there's no meeting of the minds, and so the customer of this major corporation was able to get out of that contract. Another example of no meeting of the minds is when there's duress. So let's say that one of the parties to a supposed contract exerted that is placed undue duress, meaning a lot of force, and that actually could be considered like taking over the mind of the other party to the deal. And it's hard to prove duress when you have two very capable parties who are negotiating a contract. But if there's a major corporation and then a small company that just really doesn't understand, and the major corporation says, like, unless you sign this, we're not going to give you this contract. Let's say the major corporation was the only company in the world that supplied a certain product, and there would be other details of duress, but basically forced the small company to sign this contract, and if not, then this small company would go out of business. And so that could be another example where there's no meeting of the minds, because the small company was under duress, basically forced into the contract. Another example of where there's no meeting of the minds is, like I mentioned just a couple minutes ago, is fraud, where the party B in the negotiations for the contract cheated party A and said that this contract is such and such, or you're going to get such and such, and so this is a really good deal, and so go ahead and sign this contract. And when really the contract wasn't a good deal, so that could be what's called fraud in the inception of the contract. So that's another example where really it basically boils down to that there's no meeting of the minds. And another example of where there's no meeting of the mind, at least in terms of law in California and in most other states, is where one of the parties in the contract is less than 18 years old. That's what's called a minor. And in most states, including California, if a minor, let's say a 17-year-old, signs a contract for whatever, $500,000 of whatever it might be, whether a product or a service, that minor, even when he's a minor, but for sure when he becomes 18, can get out of the contract and say that he didn't really know what he was doing, because minors don't have capacity to contract. And so the only caveat there is the minor has to promptly, very quickly, when the minor turns 18, notify the other party that minor wants to get out of the contract. But if the minor hangs on for a while, and let's say 6 months later or a year later, then comes forward and tells the company, say, I want to get out of this contract, I didn't really mean it. Well, the company could say, well, you should have come along sooner, so we're going to enforce the contract. An interesting thing about when a minor can get out of a contract, he often doesn't even have to return return the benefit of the contract that he received, whether it be $1,000, iPhone or whatever else it might be. He doesn't even have to return the item very often. That's kind of a windfall, but that's how it works in California and many states. One other example of where there's no meeting of the minds is when a person doesn't have capacity. So let's say that a person unfortunately has dementia and enters into a contract and for $100,000 of landscaping, and then the landscaping company comes over to this person's house and does all this $100,000 job on landscaping, and then the homeowners who has dementia, their daughter, let's say, gets wind of this. Obviously they see this huge landscaping job that was completed. The daughter hadn't been there a month and comes there a month later, and wow, there's this beautiful home with landscaping and new irrigation and a new hardscape and everything, landscaping, by a landscape designer. And the daughter then calls the landscaper and says, listen, my mom has dementia, and like, what are you doing? How did you agree to provide this contract? And the landscaper says, licensed and everything, says, like, your mom agreed and seemed all excited. And the daughter says, my mom has dementia, and you should never have gotten into this contract with my mom. My mom really didn't know what she was doing. So if the daughter can prove that, prior to the mom entering into the contract, that the mom had dementia through, if the daughter can prove it through medical records and whatever, and that the mom really didn't know what she was doing, and if push came to shove in a litigation, there's a good chance that mom could win that one, and the landscaper could get $0 of the $100,000 contract for the mom. Anyway, so that is the first part of this series of breach of contract. First part being meeting of the minds, or really when there's no meeting of the minds also. And so part B of this series of breach of contract, I'm going to be speaking about whether when an oral contract can work and when a contract has to be in writing.